No, no. It's child's play for you.
I think it better. Yes, yesterday I am pondering it in other ways. Anyway,
That shows that prima facie your officer is trying to cite someone.
now I would not like to answer that.
Yeah.
I would be asked. Or if the officer is concerned, he is present and he intends to apologize.
He's only physically present.
Actually, he intends. It really means to
Give it in writing. Tender apology in writing. There are lapses, and this is a matter wherein someone is has lost his life. And what he has done? જે પહેલી આંગળી કરે બીજી આંગળી કરવાનું કીધું. He has not entrusted the investigation to an independent agency. Ultimately, it will be under his control only.
even that can. Sir,
And what about the grievance of the complainant,
for that,
Mr. Amin? Will he be able to produce inward register, outward register, what actions he has taken pursuant to that complaint, and how seriously he has taken that complaint?
Can I just take a few minutes of the honorable court
Yes.
to explain before my lords consider his apology? Sir, before my lords look to this,
Yes.
can I address on
Yes,
some
yes.
material of investigation?
Before that,
Not on merits, nothing on merits.
Mr. Amin, there must be some material. I am not saying no. My only question to you is, what happened to his complaint specifically pointing out about the partial investigation, whereby he has alleged that Mr. Vasawa is not investigating the matter properly? That application was made to the higher authority on 23rd April 2023. Charge sheet was filed within 2 days thereafter. When did he receive that application?
Yet I am answering all the things. But before I do that, certain one aspect which needs my lord's consideration would be a little bit not on whether to consider this application or not to consider. That will be a different issue altogether. But only for a second I may address on contents of the FIR. The FIR is given on 30th January. As far as FIR is concerned, in all 9 accused persons are named. And out of 9 accused persons, according to first informant, 1 to 7, including petitioner before this honorable court, were present at the scene of offense. That is the case of first informant. So far as presence of 8 and 9 is concerned, he is not stating about the presence, but certainly he alleges that they were one amongst the
Involved.
Yes, but one amongst the. Now, during the course of investigation, firstly, honorable court may please appreciate the first informant, Vanraj Singh, is not an eyewitness. The eyewitness is a person named Imasi. He is the only eyewitness. Full, rather, he had occasion to see entire incident from beginning to the end. Now, after the investigation was taken over by Vasawa, Vasawa interrogated the arrested accused. On the basis of interrogation of arrested accused, he collected the call details. More particularly, it is called call dump or the details of call dump, which means that if I am placed here, my friend Mr. Mehta and Sharma are placed here, then my our three's mobile call dump would say that we are present before this particular place. And any other who are present here, their call dumps also would be one amongst we three. So that is how call drums was collected. Now that collection showed that out of 7 which were alleged in the FIR being present at the scene of occurrence, 5 were certainly present. 2 were not present according to that call details. Sir, I don't say that his job is to deliver the justice. It is the function of honorable court. But certainly at the same time, when that aspect came to the knowledge of the investigator Vasawa, not only call details, but from other sources, namely the statement of accused, he interrogated one person named Jaspal. Now, Jaspal is the person at whose house marriage ceremony was going on this particular day at this particular time. So Jaspal was interrogated, and Jaspal stated that petitioner Narendra was present at my place and was in that ceremony. That place is little distance away from the place of occurrence. So far as call details are concerned, Narendra and two other who are considered by learned session judge for anticipatory bail, their call details are showing that they were constantly in touch with the five petitioner or the five accused who were found present at the scene of occurrence. So this particular act of conspiracy is fully established, excluding the presence of Narendra and two others. Now, kindly please appreciate further. After having collected the material of alibi on the basis of applications received by the investigator, because as like the application of this Jaspal,
Yes.
Jaswansi, he also received application from three other persons. Some relative of Jayendra. Jayendra is one of the accused still at large. One relative of Narendra. Narendra, though at large, Section 70 warrant was obtained. Jayendra, though at large, Section 70 warrant was obtained. Now, after interrogating or after gathering the material of investigation, for those accused who were arrested, namely 5 in numbers, investigator submitted charge sheet. Now, it is his mistake. He should have produced that material of investigation, but subsequent thereto, he had submitted that particular material to the court of learned magistrate. Now, so far as this case diary is concerned, it will be a contemporaneous document that clearly shows that he has investigated so far as alibi aspect is concerned. And with liberty, I am very humbly submitting to this honorable court that this court time and again have said if alibi is not investigated, then investigator should also investigate whether to believe, not to believe is firstly for IO, and certainly this will be a discretion of honorable court whether to consider, because time and again it so happens that I may put my phone here and I may do something at a distance place from here. That will not establish the alibi. That apart, but that has been collected. Now, sir, kindly see, as like this, those three relatives of the accused, Jaswansi gave 3 different applications repeated. If my lords kindly look to that first application, which is dated
16 to 2023.
13 to
13 to.
2023. Now, please see what I may take 2 minutes, because ultimately
Take your own time. Ultimately,
no, I am not.
you are also trying to ensure that there is no injustice caused to anyone. Therefore, take your own time. We are not in a hurry.
So I am trying to just very, very humbly state that in spite of all this, officer is bound to respect the dignity of this honorable court, and today also, either out of repentance, either out of worry, whatever it is, openly he would apologize. But before that happens, I am trying to place what he intends to show to the honorable court. So this is an application of Jaswansi. Jaswansi is not a witness to the incident,
Yes.
but he is the son of the deceased, as like the first informant.
He has raised the grievance that investigation was not being carried out in proper manner.
Sir, that is
Yes.
for a minute, please. Now, so far as this application of 13th February is concerned, with my lord's permission, I may read that second paragraph.
Yes.
કામ શિવલેખા નીચે જણાવેલ કિસ્સાઓ આજુબાજુના વિસ્તારમાં દાદાગીરી ઝઘડા તેમજ કોમી વૈમનસ્ય ફેલાવી રહ્યા છે. જે શખ્સો પૈકી ઘણા બધા ગેરકાયદેસર પ્રવૃત્તિ સાથે સંકળાયેલ, જેમાં ઉદયસિંહ જાડેજા ઘણા સમયથી વાગડ વિસ્તારમાં મોટા પાયે ગેરકાયદેસર ધંધો કરે છે. તેમનો પુત્ર વિજયસિંહ સો લૂંટ જેવા ગંભીર ગુનામાં સંડોવાયેલ છે. આ શખ્સો પાસા તળે જેલવાસ ભોગવેલ છે. આ તમામ શખ્સોને નવલસી સો એન્ડ સો રહેવાસી સો એન્ડ સો દ્વારા રાજકીય વર્ગ ધરાવતા હોય તેનો લાભ લઈ ઉપરોક્ત તમામ શખ્સોને વારંવાર એમ તેમ પ્રકારે સાચવે છે અને ગુનાઓમાં મદદગારી હોય તેમજ આ બધા ગુનાઓમાં આર્થિક મદદગારી પણ કરી રક્ષણ આપી ગુનો કરવા મુશ્કેલ છે અને ગામમાં કહેતા ફરે છે કે જેટલો પણ ખર્ચ થાય તે હું મદદ કરીશ અને આ તમામ ગુનાઓમાં રાસુબા સો એન્ડ સો પૂર્વ કચ્છ વાળા પણ આ લોકોને વારંવાર ગુનાહિત કાવતરા કરવા અને ગુનામાંથી બચવા માટે માર્ગદર્શન આપે અને કાયદાના રક્ષક હોવા છતાં કાયદાનો ભંગ કરી પોતાના હોદ્દા તથા કાયદાનો દુરુપયોગ કરી રહ્યા છે આ શખ્સો વારંવાર જેમની મદદ કરે છે તેમના નામ નીચે
એમાં 9મા નંબરે પ્રેઝન્ટ એપ્લિકન્ટ છે.
Sir, I don't say no.
Yes.
My lords are absolutely right. There are item number 6 is Jayendra. Probably Jayendra also is
Yes.
accused.
He also has
FIR accused.
said that he was not present at the scene of offense.
Mumbai is also figuring in this list. Then he gives the number of FIRs. Then again, little later he says કે આ બધા સામે ફરિયાદ અરજીઓ પણ થયેલ છે જેની જે તે સમયે તટસ્થ તપાસ થયેલ ના હોય આ શખ્સો વારંવાર ગુનાહિત કૃત્ય કરતા રહે છે આ શખ્સો વિરુદ્ધ જે અરજીઓ થયેલ છે તે અરજીઓની વિગત નીચે મુજબ છે અલ્ટિમેટલી he concludes by saying
9 પૈકી 5 ની ધરપકડ કરવામાં આવે છે. That's what he says.
Yes, my lord. Now, on the basis of this application, his statement was recorded. That statement would be at page 4 immediately after
5-3.
5. It is also signed by the person who has been
Yes.
interrogated, that is the Swansea. I may read the concluding part rather the sentence even from middle part of the page. ઉપરોક્ત ગુનાના કામે અમોએ ફરિયાદ આપેલ ત્યારબાદ થોડા સમયમાં આરોપીઓમાંથી 5 આરોપીઓ સો એન્ડ સો તથા ઉદયસિંહ, અબુભા, જયેન્દ્રસિંહ, નરેન્દ્રસિંહ આ દિન સુધી પકડાયેલ ના હોય જેથી તેઓને તુરંત પકડી પાડવામાં આવે અને આ લોકો અગાઉ અનેક ગુનાઓમાં સંડોવાયેલ જેની એફઆઈઆર ની નકલો પણ અરજી સાથે સામેલ રાખેલ છે જેથી અમારી સમૂહ પોલીસને વિનંતી છે કે બાકીના 4 આરોપીઓને તુરંત પકડી પાડવામાં આવે અને તપાસ તટસ્થ કરવામાં આવે જેથી અમોએ આ અરજી કરે છે અમારી આ અરજીમાં સ્થાનિક પોલીસ તથા જિલ્લાની બ્રાન્ચો દ્વારા આરોપીઓને નહીં પકડવા બાબતે તથા તટસ્થ તપાસ નહીં કરવા બાબતે તેમજ બનાવના મુખ્ય સૂત્રધાર નવલસિંહ છે અને ગુનાની તપાસ ઉપરી અધિકારી દેખરેખ હેઠળ કરવા લખેલ છે જે બાબતે પૂછતા જણાવું છું કે અરજી અમારા વકીલ મારફતે કરેલ છે આવી કોઈ બાબત અરજીમાં લખવા માટે કહેલ ન હતી તપાસ બાબત સંતોષ છે અને બચાવ ડીવાયએસપી સાહેબ પણ તપાસમાં આવે છે. Now I am not on anything beyond what has been stated. For the time being, even honorable court may say that for whatever reasons, this is a statement. Now please see, after this statement, the next application. Next application at page 5, 11/4/23.
Yes.
Now 11/4/23 also relates to stating about non-arrest of certain persons.
It is addressed to IG.
It is now that my lords. What happened? What is happening in the entire district, not only in Kutch but in every district of our state? In a month, around I say, 200 applications are received. Some would come from the office of Honorable CM. Some would be directly addressed to IGP. Some would come to SP. Now, whatever applications are coming to IGP would be sending it to SP. Whatever applications are coming to SP would be directing it to the concerned investigating officer. So, in this case, Wasawa. But so far as this
But when the
application
complaint
is
itself
concerned,
is against that IO, is it not their duty to look into the complaint and take the corrective measures?
what has happened? They had gone to the court of landed magistrate for issuance of section 71.
11/4 થી 25/4 સુધી ત્યાં જ ધામા નાખીને બેઠેલા.
I am not here to protect anything. What is calling from the honorable court certainly is very serious, and every police officer present here and even outside should take care of the situation that whenever accused is not available, sincere effort should be made to see that they are available. if they are not apprehended and they cannot arrest them, then the recourse available under the code is to get the warrant of 7.
Mr. Amin, why it raised suspicion, I tell you. First, even that statement which was taken on 5th March was taken by that Wasawa only. The complainant tells the Wasawa that no, I have not done anything. I have done whatever I have done is under the instructions of my advocate. And immediately after 1 month, he again files a complaint to the IG for the reason that he may be it might have been threatened or he may be ill-treated or whatever, I don't know. Wasawa gives a clean sheet to himself by way of this statement. In how many matters have you seen such kind of statement? While investigating the matter, the investigating officer himself records a statement giving a clean sheet to him that no, I am satisfied with the way the investigation is going on. That is first thing. Second, he keeps everything under his sleeves. He says that though I have some material, I have produced it along with case diary before the magisterial court, but he doesn't make it a part of charge sheet. Even before the trial court as well as this court, the affidavit which is filed, he forms an opinion કે આનો રોલ તો ખાલી બેલ લેતી વખતે ફાઇનાન્સ કરવા પૂરતો હતો. Today you are saying that he was actively involved in conspiracy and section 70 warrant was issued. Why all these facts were not, and on what basis he arrived at a conclusion that his role was only limited to only financing at the time of bail? દેખાવો ક્યાં છે affidavit?
Affidavit, I understand. So far as contents of
Then on what basis he is filing? He is filing an affidavit before the court. He takes court proceedings so lightly. Then what is the material for that?
he cannot get to do that. But I certainly I will.
If a false affidavit is filed, will it amount to an offense under section 194 or 211 or 218, 468?
Our IPC is such that any act, or even for that matter omission,
Then why even a police officer should be spared for filing false affidavit before the court?
ultimately, if
Tell me what is the material. I am not saying, Mr. Amin, show me from investigation papers that there is any basis for filing that affidavit that his role was limited to that extent. Is it not an attempt to give a clean sheet to this accused applicant?
sir, then can I just take my notes few minutes from so far as that affidavit is concerned? So that affidavit is at page.
If there is a material,
No.
I'll believe it. But despite looking at the charge sheet papers twice, on that day Mr. Gondalia also was there. Even Mr. Barot also could not point out that this is the statement on the basis of which this opinion was formed.
So can I just take my lord's few minutes, sir? Page
Yes.
35, Wasawa in his affidavit states like this. આ કામે મરણ જનાર તથા ઈજા પામનાર બંને સોડા કેમ્પથી શિવલખા જવા નીકળેલ ખોડિયાર જનરલ સ્ટોર દુકાન આગળથી 12:50 ના અરસામાં નીકળે છે. ત્યારબાદ થોડી વાર પછી તુરત જ આ કામે આરોપી દશરથભાઈ ની ગુનાના કામે ઉપયોગમાં લેવાયેલ અલ્ટો કાર પાછળ
Mr. Amin, his role comes at page 36.
So I am showing that CCTV camera etc.
No, he may not be present at the scene of offense. You are absolutely right. I believe that. I am on the basis of what prompted him to file an affidavit to
Yes.
this effect.
Yes, certainly I am obliged to my lord. Page 36, line number.
આ કામે અરજદાર આરોપી તથા સહ આરોપી સાથે અગાઉ બનાવેલા પ્લાન મુજબ અરજદાર નરેન્દ્રસિંહ કાળુભા જાડેજા પોતે એક જ ભાઈ હોય અને સદર ગુનામાં પોતે જેલમાં જશે તો પોતાના પરિવાર અને જમીન સંભાળનાર બીજું કોઈ ન હોય,
I am reading my
તેને માર મારવા માટે સાથે રહેવું નહીં, પણ જેલમાં તમામ લોકોની તમામ પ્રકારની મદદ, જેમ કે જામીન પડવું, કોર્ટ કચેરીના ધક્કા ખાવા, આર્થિક રીતે મદદ કરવું, એ પ્રકારનું
ભેગા મળી આરોપીઓએ ષડયંત્ર રચેલ તેમજ રોજબરોજ અરજદાર તથા આરોપીઓ ફોનથી સતત સંપર્કમાં રહી 30/1/23 ના રોજ રચેલ ષડયંત્ર મુજબ સદર ગુનાને અંજામ આપેલ છે. તેમજ આ કામે આરોપીને ખૂન જેવા ગંભીર ગુનામાં આગોતરા જામીન મળી જશે તો તેઓ ગુનાના કામે કોઈ સાથ સહકાર આપશે નહીં અને હજુ પણ તેઓ પાસે તપાસના કામે જે પણ વધુ પુરાવા મળી શકે તેમ હોય તેવા તપાસની કડીઓને જોડતા પુરાવા સુધી પહોંચવામાં વિઘ્નરૂપ સાબિત થશે, જેથી આરોપીઓને પોલીસ કસ્ટડીમાં લઈ તેઓ વિરુદ્ધ વધુ પુરાવા મેળવી શકાય તેમ છે અને ખૂન જેવા ગુનામાં આગોતરા જામીન મળી જશે તો તેઓ ગુનાની તપાસની એનકેન પ્રકારે નુકસાન પહોંચાડશે તેમજ બેફામ બની કાયદાનો કોઈ પણ જાતનો ડર રાખ્યા વિના સ્વયં પોષણ. Now the basis of stating this in the affidavit is the statement of Himmat, arrested accused, statement of another accused Indra Singh, and statement of another accused, three accused Anil. So on the basis of that statement, this particular version had been stated. I can even place those statements.
I believe you.
No, these are the statements.
Once it falls from learned PP, I believe it.
Sir,
But my point was that despite investigating according to you as investigated, what was the necessary not to place those documents along with charge sheet?
I take her bow down, absolutely bow down, and I had to suffer for it. He had been withdrawn, etc. But again, sir, at the cost of reputation, can I? In a minute, sir, I may. I will have some. Sir, can I make a statement? From by noon, investigation will be handed over to some other district. IG is present here. I have taken sense of IG, and IG by noon will transfer the investigation to some other district totally different
That is
than
fair.
this particular crime division. And
Once he has realized this mistake, I don't want to embarrass him in front of lot many people because he also holds a very reputed post, but he should be careful. That's what I can say. I'm not. What do you want? You want a reasoned order?
I might be allowed to make this one or two submissions. The learned PP, refer to the papers. which
Now,
have
at
been
least
handed to-
even after all this exercise, fact remains that you have actively participated in the crime. You are one of the conspirators. There are call records. Why you should be enlarged on anticipatory bail in a matter like murder?
So there are two facts. So far as whatever he has averred in the affidavit, that could not be brought to the notice of the Honorable because there were no supporting statements for it. They have been brought to the notice of the Honorable Court only after Your Lordship's to
By way of an affidavit, they can place it on record.
That is one thing. And secondly, my lord,
Or that material that it is already before the magisterial court, right?
Already before the court of learned magistrate, and sir, it's a practice there that
Yes.
whatever papers are submitted, that those papers will certainly go to the accused as and when they are produced before the court of learned.
there are two sets of statements. One, my lord, which are recorded under section 162 and one which are recorded under 164. So far as 164 are concerned, the practice is that they are put in an envelope and produced before the court of learned magistrate. They do not form part of the charge sheet. The accused would not be entitled to have an access to that. That is fine. But so far as the statements which came to be recorded, my lord, during the course of investigation, my lord, they have also been withheld. Your lordships have already observed that. And my lords, the three statements on which my lords, Mr. Amin relied are the statements of the co-accused. My lords. There is no other independent material, whether that's co-accused is Amrat, Himmat or Anand. My lord. But besides that, there is no other material which is coming forth for your lordship's
You are at the
consideration.
stage of anticipatory bail.
I understand, but your lordship,
Investigation qua you is going on. It is not over.
certainly, investigation is certainly going on, but the statements which have been relied on, lords, in order to implicate me are the
That
statements.
I will take care. Don't worry.
Well, it's my duty to point out to your lordships that though they are absolutely barred under 25 of the Evidence Act, lords. Only on the strength of the statements of co-accused, if I am going to be pinned down, my lords, that would be something which your lordships may like to consider, your lordship. And then whatever the call record CDR is there, that is also not forming of the charge sheet, my lords. Your lordships on the very first day inquired of me whether that
I
is
will
formed of
record in
charge.
the order everything what has happened till date.
So that is also, the CDR is also not produced along with the charge sheet. It's now that they are coming and saying that there have been interstate communications or call records.
Because investigation qua you is not over. Maybe that will form part of charge sheet at the time when charge sheet qua you is filed.
But so far as, no,
Today I am considering anticipatory.
I
bail
understand.
application after
I-
application after charge sheet.
I understand. But so far as the accused, 5 accused who have been already arrested against whom charge
That
sheet
is
is
that
filed.
investigation.
Again, in their investigation papers as well, no call records has been produced for us. No call record. Either interest of those accused or call records between those accused and other person. And I would just, I would leave. No, I would then not invite orders.
Chalo, learned advocate Mr. Tejas Barot upon instruction seeks permission to withdraw this application. Permission as prayed for is granted. Learned APP Mr. Amin assisted by learned advocate Mr. Manan Mehta. I am not recording any statement, but I hope that it will be entrusted,
I will make a statement at 2:30.
not required. Once you have stated before the court, that is sufficient.
Going outside, sir, I will. I think he has to.
There is one more submission, if your lordship like to. Lord, the family.
Now, after you have withdrawn.
No, not on the matter. Not on matter.
Yes.
Lord, the family of the present applicant, the father has been day in and day out called at the police station. He is not involved, Lords. He is only, and he is pressurized that you please make him surrender, Lords.
You file appropriate application before appropriate court. Sure.
But Lord, this is causing unnecessary harassment. The lordships may kindly, Lord, at least it may be impressed upon that.
Have I observed anything in the order?
Your lordships have not.
Thanks.
Very well.
I'm grateful.
I'm sorry for troubling you again and again, Mr. Member.
Not say. It is my duty and function to assist honorable court. All the police officer, not.
But you
only
know the
SPI and
purpose now.
IGP, everyone has to assist honorable. No one is exception. I am grateful.